Hello, and today we're going to be having a look at damages. Now, damages is a remedy for whereby there has been a contractual breach. This is a standard go-to remedy normally when a contractual breach has occurred, which can be distinguished from, for example, specific performance, which is an equitable remedy and would only tend to arise whereby damages were insufficient in terms of remedying the contractual breach that has occurred. So the whole aim and the point of having damages is you put the parties in as good a position as they would have been had the contract been performed. So you're not going to be putting an amount for damages which is more than if the contract had been performed. It's just to put the parties on a level playing field. And this principle arises from Baron Park's remarks in Robinson and Harman. Now, this can be distinguished from the US system, which is a more punitive system of damages, where you want to punish the party for actually breaching a contractual term. Now, this does not mean we don't have punitive damages in English law. It just means they tend to be limited to very specific facts and very specific scenarios. So let's have a look at the case of Drain and Evangela. Now, before continuing, all the cases I'm talking about in this video are relating to leases. And the great point about using all the cases relating to leases is you can actually clearly see, because a lease is a specific type of contract, and if you're comparing the same kind of contracts, then you can clearly see what are the different legal principles coming out when we're looking at damages. This will make more sense towards the end of the video, I think. Anyway, in the case of Drain and Evangela, so we're looking at when does punitive damages actually occur in English law. So what happened is there was a case of unlawful eviction. So Drain, the tenant, he had gone out one morning with his girlfriend, and the landlord had come and trashed the place and moved his stuff out, and it was a case of unlawful eviction. So why did the landlord do this? Well, in a nutshell, Mr. Drain had gone to the rent officer and he had got his rent reduced, I think, from £25 a week to £16 a week. And this really annoyed the landlord because he just wanted him out of the premises because it would just work out cheaper altogether. And he wasn't getting his way. He had even, I think, issued a notice to quit. So he came in and he did this. Now, what happened is legal proceedings were brought for unlawful eviction. It went through the courts, and again they were said, no, this is unlawful eviction. But what the landlord kept doing is sometimes he had his mother-in-law and father-in-law living in the property. Sometimes he himself went and moved into the property. So he was doing some crazy things, basically, and he was not allowing the tenant who should be there to be there. So it wasn't until 10 weeks later till Mr. Drain got back his premises. And when he arrived with his girlfriend, it was of substandard condition. It had become so dirty, and it was just, not of the quality that he was expecting and should be living at. Anyway, to cut a long story short, how this relates to damages, when he came to receiving damages, he had been, the courts had basically said £1,000 of damages is the right amount. Now, even Denning said this was an exemplary figure, because if you think about it, for a £16 a week rent, £1,000 in damages is a lot of money. So what was going through the court's minds? Well, there was a few different things. The courts were looking at the fact that actually what the landlord had done was also conducted a tort. It was a tort of trespass. He had come into the building when he was not allowed to, and he had trespassed. So, and in tort, you can have exemplary damages which go beyond the Robinson and Harman principle. And they were also looking at the fact that we want to secure a stable, law-abiding, secure society. And it was a policy decision, and they were just so shocked by the facts and the way and the recklessness with which the landlord had acted that they said, no, hold on here, we're going to award this big sum. Normally in contracts this would not happen. It's very particular, it's on certain facts, and in this case, the facts were as such. The judges said, and they justified it by saying, look at tort and look at what's happened, and they justified it all these different ways, and £1,000 was awarded. More generally speaking, though, we have two types of damages when we're looking in terms of Robinson and Harmon principle. You have general and you have special damages. So what's the difference? Well, general damages are the more common damages. They cover the loss experienced by the party who's been done wrong by, that's been occurred directly and necessarily as a breach of the contractual term. So, for example, let's look at the case of Owen and Gad. Again, we have a lease of a shop. So what was happening is, as with any lease, you tend to have a provision for quiet enjoyment. So the tenant should have quiet enjoyment of his premises. Now, on top of the shop, the landlord wanted to conduct some repairs, so he erected some scaffolding. The result of this scaffolding is it didn't completely get rid of access to the shop, but it did hinder it, which, as you can presume, the shop itself had suffered some financial loss because access had been hindered. So they went to get damages, and the courts awarded damages. They were nominal damages, and they were just general damages, what you can foresee. And they followed the Robinson and Harmon principle that we're going to put the tenant back in place as good as if the covenant to quiet enjoyment had not been breached. So if we move on to special damages, now these are a bit different. They cover any loss incurred by the breach of contract because of special circumstances or conditions that are not ordinarily predictable, but the landlord could foresee because he had the knowledge of it. So if we look at the case of Grosvenor Hotel Company in Hamilton, what had happened actually is the landlord was suing the tenant for the breach of a covenant for rent, and the tenant counterclaimed for nuisance caused by the landlord, because during the course of the lease the landlord had pumped water from an adjacent land by the means of powerful engines, knowing full well that there was a business which was running here, and also that the property would not be able to handle these kind of powerful engine water pumping machinery things that were going on in the land adjacent to it. And the vibration, they really damaged the premises in question. They damaged it so much so that the business couldn't function and they had to relocate. So what was held was that, yes, damages were recoverable by the tenant, but they were not just confined to the value of the term for which he had lost, but they were also going to extend to natural consequences of the wrongful act. So, for example, a natural consequence of the nuisance committed by the landlord was that the tenant would have to relocate. So the cost, or I should say the loss, the financial loss in relocating, he was able to claim that from the landlord. Now, this is not something that would ordinarily be expected, but the landlord had an idea of it, and he was able, and he's still going ahead, breach the covenant, knowing that the premises would not be able to take it, and there was a business which was running, and so yeah, that's a type of special damage compared to the case of Owen and Gad, which was general damages. Now, damages are also limited by statutes and statutory examples. So in a lease, you tend to have a covenant, to repair the property. Now, where this repair clause has been breached, basically the damages are restricted as per the statute. So section 18(1) of the Landlord Tenant Act 1927, it says that there will be a ceiling on damages, that they can't be more than the loss in value of the reversion. So by reversion we mean once the property is ended, the value of the new lease that would occur once the term finishes. So the loss to that caused by the lack of repair, it can't be more than that. And you cannot claim damages at all if the premises was to be demolished or altered anyway, because it wouldn't make any sense. And actually what they're saying in section 18(1) is just basically reinstating the Harmon and Robinson principle in a different way. So I hope you've enjoyed this video, and as I said, I use all examples of leases because they all are, a lease is a lease. It's you're looking at a premise being rented out, and it just clearly gives an idea of what are the contractual legal principles at play here. Thank you for watching.